Welcome to Law Talk. In this web series, attorneys discuss the laws and the legal processes. With these videos, I hope to give my viewers and the general public an unvarnished view of the justice system within New York State. Our topic today is a very interesting one, and I hope you enjoy it. So the question we will be answering is, why should I trust, or why should you, the viewer, trust a lawyer? And to help to answer that question, I have a good friend of mine here today, Cy Eidner. Cy was a prosecutor. He has prosecuted hundreds of attorneys for wrongdoing. Now he is in private practice. He defends attorneys, and he handles personal injury cases and also tons and tons of appeals. All right, so just by a little of a history, Cy and I are old friends. We went to law school together many years ago. Welcome, my friend.
Ruben, thank you so much, and it's good to be with your viewers today.
Okay. All right, so can you tell us just a little bit about yourself?
Well, I've been practicing law for 16 years. I'm based in Mineola, and principally do personal injury and, like you said, appeals. And I also defend attorneys who are under investigation by the court system through what's known as the Attorney Grievance Committee.
Okay, so let's hit it. Let's talk about, why should people trust lawyers?
Well, first of all, I mean, pragmatically speaking, I mean, you have no choice. Once you hire the attorney to get you through whatever issue you have, whether it's a traffic ticket, a divorce, or something even more significant than that, if
Right.
such a thing exists, you have to trust the person that you've hired.
Right.
The issue of whether you should trust the person you hire is a whole nother story.
Right. The should trust part, I think, deals more with your ability to read people, right?
That's right. I mean, when I think about trust and trusting an attorney, I always think of two things really come to mind, two components. The first is the tangible aspect of trust, which is the attorney going to steal my money? Is he going to charge me for something he didn't do? A whole host of activities that I think would implicate your moral compass in a black and white way right away. Then there's trust from its intangible standpoint, which is, or involves really, did I hire the right person? Does this person have a plan for me? Is it individualized? Does he or she really know what they're doing? And are they going to put the time in to get me the best result?
Right. And actually, Cy and I had been talking about this, and he previously mentioned a really good point. How do you know if you're going to trust your friend? How do you evaluate people generally? So you follow your gut, essentially. Yes?
I think you always have to trust your instinct, especially when you are meeting an attorney for the first time, or attorneys as the case may be, and deciding, who do I hire to get me through this particular issue in my life?
Right.
And I think you have to be guided by your instinct. Now, some people, Ruben, don't have good instinct, or their instinct is clouded by some reason or something. But I think generally, you have to trust your first impression of somebody.
Right.
As long as you do certain things to ensure that you can rely on those instincts.
You mentioned initially, is my attorney going to run off with my money?
Right.
What's the risk of that happening? And also, if that does happen, what do people have to do to get their money back?
Sure. If you're concerned with attorney theft, I mean, just statistically, it happens extremely infrequently. But if it does, there are specific mechanisms in place, both from a criminal and non-criminal standpoint, to ensure that the attorney is held accountable for his or her behavior. And that's where the Attorney Grievance Committees come in the state of New York. There are 4 departments in the state of New York, numbers 1 through 4. Each one has an attorney grievance committee, and what they do is they are responsible specifically to investigate any claim of misconduct, and that would include theft of money and things relating to financial misconduct. And they have the ability to immediately take the attorney out of professional commission by suspending his or her license, disbarring the attorney, or taking other action similar to that.
Right. So essentially, what Sai is telling us is that New York courts have a specifically designated department within the court who are responsible to go and prosecute other attorneys who have somehow wronged their clients or the general public. Now, that particular department is called the Attorney Grievance Committee. And if you feel like you've been wronged by a client, by an attorney, then you have the right to file a grievance with the court. But should they file? That's the question. And I mean, practically speaking, what's better, to file it or to talk to their attorneys?
Well, I mean, I wouldn't recommend anyone file a grievance until you've had a really good conversation with your attorney about the underlying issue in that relationship. Grievances are not things that should be taken lightly because they bear potentially career-altering ramifications. Now, with that being said, I think the appropriate thing to always do in any relationship is to try to discuss the issue. And depending on the information that you get, or the information that you don't get, as the case may be, the grievance process is there for you, potentially in order to right some wrong. But I wouldn't do anything that significant until I've had at least one very significant conversation with the attorney about the underlying issue.
Right. I do arbitrations for attorney fee disputes. It's called, there is a law, and Part 137 of that law says that clients can seek to resolve any disputes they have with their attorneys by way of arbitration. So I'm an arbitrator. It's all done on a pro bono voluntary basis, and so I get these cases often. Now, what it is that most of the time, the claim isn't that my attorney ran off with my money. Most of the time, the claim or the clients feel like the attorney did not do enough work, and they billed me for services that was not necessary. So an arbitrator would have to decide whether the fees that are charged by the attorney are reasonable. So now let's talk about that. How does someone, when they're going to hire an attorney, how does that person know that this attorney is not going to just charge them for services that, or for things that the attorney didn't do?
Well, I think initially you have to operate under the presumption that the attorney you're hiring isn't going to conduct him or herself in a way that's unethical. Because charging for work that you didn't perform or charging for work that's really unnecessary will violate the rules of professional conduct. And I think you should take that assumption into any relationship, so that at least you get off on the right foot.
Right.
Because if you're hiring somebody that you don't trust out of the gate, I can tell you almost certainly that that's going to end up in disaster. That's where you have to trust, your instinct initially. But there are mechanisms in place if a client believes that he or she has been charged in an inappropriate way. They can go before you for that fee arbitration.
Mm-hmm.
And depending on the circumstances, they can bring a grievance concerning the fees themselves. Although generally speaking, a grievance committee will always defer to a fee arbitration, there are circumstances in which it's no longer about a fee arbitration, but rather the billing or the practices have become now a matter of the rules of professional conduct. That is, the fees, the practices of fees,
Right, it's just so outrageous.
Implicate
the billing
professional
practices,
misconduct.
right, is so outrageous that, and I mean, off the top of your head, Si, I mean, how outrageous does it have to be?
fairly outrageous because there's a strong deference to litigating these issues or resolving these issues before someone like you in a fee arbitration in lieu of a grievance committee investigation. It has to be quite significant.
Right, and you know, frankly, I do have to admit, from the standpoint of a non-lawyer who has to hire a lawyer, and the lawyer who has to do most of the work, a big, huge chunk of the work is done in the office, not in front of the client. You know, it's difficult. It's difficult for people that don't know what is happening behind the scenes to say, oh yeah, you know, he did good. Yeah, all of these times that he charged me or she charged me is fine. So, but again, I think I would say, and I think Si would agree, that just you know, listen to your gut instinct. Okay, when you first meet the attorney, what would you want a good attorney to do?
I think the most important thing from an initial encounter with some attorney that you want to retain is get a sense of whether they're going to treat you and your issues in an individualized way. Because the reality is this: most attorneys can handle most matters, but I think very few can really ensure that you get the best outcome from a range of possible outcomes that range from probably crappy to extraordinary.
Right.
And so when you first sit down with the attorney, or you do it virtually now because of the times that we're in, one thing I would really focus on isn't the volume of information you're given. I would rather focus on whether the attorney is giving you information that you honestly think is specific to your personal issues. Because the rules may be the same in terms of matrimonials or attorney discipline or personal injury, but every case is unique and has its own pitfalls.
Right.
A good attorney should be able to identify most of those pitfalls pretty quickly.
Right.
That is on their feet if they've been doing it for a long time. And if they communicate that to you, I would take that as a very strong sign that you have somebody that you probably want in your corner.
Right.
So be careful in terms of being able to distinguish between being told a lot but said very little. It's kind of the way I think about it.
Right. You ask questions, okay, and is the attorney that you plan to hire listening to those questions, right?
Correct.
You ask questions. Does the attorney that you plan to hire, are they asking you questions that are specific to your situation? Because frankly, how would an attorney be able to do anything for you if they have not asked you and if they do not know what your particular situation is? I'm a divorce attorney. I've done many divorce cases over the course of my career, and not one of those divorce cases is the same. So if I meet my client, the very first thing that I do is ask questions, and I can tell you the questions right off for matrimony. How long is the marriage? Are there children? What are your assets? What are your debts? What is your income? What is your spouse's income? These are all questions that I need to know the answers to for me to figure out, one, how strong or how weak is your case? And two, am I going to be able to get you what you are entitled under the law? Okay, so I mean, I think it's just so critical, that an attorney asks questions of a prospective client, and I think again, you mentioned, Sai, that some attorneys have a way of talking a lot and not really saying anything, right? So how would you, what would you advise people to kind of to hone in on that, and how to
Sure.
recognize that?
I would say it's as simple as, if you ask the attorney a particular question that's unique to your situation, make sure you get an answer. Now, it's okay for the attorney to say, I don't know, or I have to look that up. And to a certain extent,
Right.
that could probably give you a certain degree of comfort with that person because they're being honest. I mean, I don't have all the answers to everything that I handle, and probably neither do you. And that's going to happen from time to time.
Right.
So if somebody is willing to say, I don't know, I take that as a very positive sign. But there's a difference between the sales job and
Sales.
facts that directly, or the game plan, if you will. I think what you want to do is hear the game plan with some degree of specificity. I know attorneys, Ruben, that really don't like to give much information during that initial meeting. They feel like they're going to give the house away, or they're going to say something that the client can take to another attorney. And that's a lot of nonsense as far as I'm concerned.
Yeah.
And it probably demonstrates to you somebody that you don't want. I mean,
There's no confidence there, right?
there's
that's
no
basically
confidence,
what it is.
and the idea that somebody's hiding, the sauce,
Yeah.
the recipe for the sauce is really bizarre.
There is nothing hidden. The laws are public, and the public is charged with knowing the laws, even if they don't know it.
Right, but beyond that, even, Ruben, the attorney should be willing and should want to provide you with information from his or her experience.
Right.
In terms of what the pitfall is, what the pitfall is not, where you're strong, where you're not,
Right.
as it relates to the individual issue that you have that you've presented to the attorney. If you can't get at least a reasonably clear answer, I would take that as a very bad sign.
Right.
Because ultimately, the first impression, I believe, is what's going to carry throughout the entire case. I mean, I try to answer every question I can as directly as possible,
Right.
Good or bad or otherwise. And if you're getting non-responsive answers, as we say in our business, that's something you should be attuned to that, and that's something that you should probably use in deciding to not retain that attorney. So you have to pay very careful attention to, did I get an answer? Does it sound like this attorney, on his or her feet, is even capable of giving me an answer? And if the answer to those questions are yes, I think you've gone a long way towards satisfying yourself initially.
Right. Okay. All right. So let's talk about the professional rules of conduct for attorneys. What is that? Who comes up with those rules, and how does it apply to attorneys' conduct?
Sure, it is essentially the rules that govern how lawyers are to conduct themselves while engaged in the practice of law, and to be honest, Ruben, under certain circumstances, while they're not engaged in the practice of law. Because there is one provision that's extremely broad and can apply to attorneys just misbehaving
Right.
while not being an attorney, so to speak. They're black and white like anything else. There are different interpretations of different rules, but
Right.
You have to take a specific test. There's an ethics test. There's an ethics component to the bar exam as well,
Right.
which
right.
I know you know, the MPRE.
Yep.
So the ethical rules that govern our lives as professionals is something that's known to all attorneys. Some attorneys know them a little better. Some attorneys have to know them a little better because they engage those rules for a living. But they're there and they control everything that we do.
Regarding handling of money, do the rules of professional conduct address that, and how?
Sure, in many different ways. So you have generally escrow money and non-escrow money, for lack of a better term. Escrow is money that an attorney holds for the benefit of some third party. It's not the attorney's money. It goes into a designated escrow account, and the bank has to report to the court system if there is a dishonored check. That will trigger an inquiry by a grievance committee. into why that check has been dishonored. Theoretically, you should never have a dishonored check out of an escrow account because principally that's not your money. And that will cause a potentially significant investigation automatically.
Right. So essentially, attorneys have two types of bank accounts. One is often referred to as the operating account, which is the basic business account that any business owner can have. Another one is the escrow account, and it's actually referred to as the IOLA account or IOLTA or trust account. So the escrow account is a bank account that's designated as an account where an attorney, when we have to hold money for a client or for a third party, we deposit that money in there. Now, if for some reason there is a bounced check, then the bank has to automatically report that bounced check and report that to the courts, and that triggers an investigation. Correct?
100%.
Okay.
Without fail, I might say.
Right. So, by the way, all of these things, the escrow account and the handling of escrow accounts, they're not new to me as an attorney, and all attorneys know about it or should know about it. And knowing about it is what you can trust that an attorney is going to worry about how they handle your money. Okay, because if an investigation is triggered, then prosecutors such as Sy have the right to disbar that attorney ultimately, and that's the harshest penalty, right?
That's right.
Disbar. Disbarring means no more livelihood. Means if an attorney has children, they don't eat, and that attorney who got the privilege to practice law within this state or actually any other state within the U.S. will not have that privilege anymore. And most attorneys, and Sy is aware, of course, most lawyers these days have a lot of student loans. They paid $100,000+ to get that privilege of representing clients, of running to court, and of playing the Tom Cruise character, right? You don't, so, $100,000 of loans, they still have to pay even if they're disbarred. So that's what you trust, right?
Well, thank you for reminding me about my student debt route.
Oh, we all love it.
I knew you were going to get there at some
15,
point.
16 years out, we all love it. Okay, as everyone is aware, I do divorce law and family court issues, family law. The rules of professional conduct and the courts force me to give every single client that retains me a statement of client's rights and responsibilities. And you've had to deal with this, yes?
It's actually a very big deal if you're not given one.
Right. So
From a disciplinary standpoint.
Right. So if you have some family law issue and you go to an attorney and you decide to hire that attorney, and that attorney does not give you the statement of client's rights and responsibilities, then that's a flag for you. Just know it. Okay? So I mean, is there anything that you want to mention specifically about? Have you had prior cases regarding?
Usually those cases come up in the context of they haven't been given, they haven't been referenced, and the client has no idea that they even exist.
Right.
And that comes up incidental to some other claim of misconduct.
Right.
Because usually when there's an investigation, quite often there's going to be a request to get the underlying retainer or engagement letter. And with that, you probe to see if there are other potential flags. And if the retainer or engagement letter doesn't reference the fact that there's a statement of client's rights and responsibilities, then you ask more questions.
Right.
And you see if that was given. And then quite often, the answer is no.
Right.
And that's a whole different basis and a whole different avenue of misconduct against the lawyer.
Right. So actually, now that you brought that up, I think the answer to should I trust a lawyer is yes, you have to. But before you retain a lawyer, ask questions. And I think actually, you know, in my own practice, and I've represented many different people, I think people don't ask questions. And because people don't ask questions, in entering any kind of an agreement, you have prenuptial agreements, you have separation agreements. If you don't read the agreement and you don't ask questions about it, you're gonna be in trouble. So now when you're hiring a lawyer, you know, a part of the process is that you sign a retainer agreement. If you don't read that retainer agreement, if you don't challenge some parts of it, it can't be take it or leave it, right? I mean, most of the time.
Theoretically, Ruben, everything is negotiable.
Everything is negotiable.
Theoretically.
Yeah.
And I think a lawyer's willingness to negotiate is a good sign that they're interested in the case.
Right.
For sure. Because if somebody's willing to walk away, whether it's an hourly rate or some disbursement or expense,
right,
it shows you that they probably don't care enough to have you around. So I would say that that's a flag.
Right.
And one thing that I think your viewers should do, regardless of what lawyer they want to hire or what their underlying issue is get a good understanding as to what a genuine budget is in the case. Because every case has different phases that cost certain amounts of money that a good lawyer will know, probably within a 5 or 10% degree, what it's going to cost to do a proper job.
Right.
And that's something that you should get at conversation number 1. And I think a good lawyer will be able to give you real detail.
Right. Okay. So I want to talk about some of your, cases that you've prosecuted, and like just some of the issues that have popped in your career. Is there anything that that you want to talk about?
Sure. The foremost, when I was investigating lawyers for a living, probably the foremost complaint was a lack of communication between attorney and client. The lawyer doesn't return my calls, texts, doesn't return my emails, as the case may be. That's probably, I would say, number 1 on the hit list of complaints, or the reason why a complaint has been filed. And from the standpoint of the attorney, that's probably the easiest one to avoid,
right,
to a certain degree. Now, realistically, some clients are unreasonable. They will pepper a lawyer with calls.
Right.
And understand that a lawyer is not obligated to respond to every single inquiry, and they're not obligated to be on call 24 hours a day. That's only something you do, Ruben. But the reality is a lawyer is obligated under the rules to give updates concerning material developments in the case and to respond to reasonable requests for information. And a lawyer should also always do so in a way that can be documented for everyone's protection. But
right.
Communications was an ongoing issue when I was there for almost 4 years, and it's probably going to be an issue forever.
Right.
Because that speaks of the quality of the interpersonal relationship between client and attorney.
Right.
Which is
right.
usually not as good as you would want it to be, at least in my experience.
Right. Yeah, and also, communication, yes, it's an issue. A person, an attorney who cares about your case is going to communicate with you. So the answer to the question of should I trust my attorney, the answer is yes. You have to. You have no choice. However, before you retain that attorney, ask questions. Keep your eyes open. If you are going to sign a retainer agreement, read it, ask questions about it, and be mindful. Is this attorney asking me questions about my particular situation? And if he or she is not asking the questions, then how do you know that that person is going to be able to represent you? How do they know if they're going to be able to win anything for you? So pay attention and trust your lawyers. I would trust them. I know a lot of them.
I would trust you.
Okay, all right. Thank you, everybody.